Hello everyone, welcome to Manika IAS. So we have been discussing fundamental rights and so far we have covered Article 12 till Article 18 and we have covered right to equality. From today onwards we'll be starting with the right to freedom. There are four articles under right to freedom, which are Article 19 to Article 22, right? And before we actually get into the provisions of the fundamental right to freedom, let us first understand the meaning of the term freedom. Now, what does the term freedom implies? Okay. See, freedom in very simple terms means the state of being free. State of being free. But now the question is how and from whom we need to be free from. Okay. So first of all, that how? If you are able to express your will freely, you know, whatever you want to do, you can do without any external restrictions or obligation. That is the simple meaning of the term freedom. Okay. Now, let us come to Article 19, which is the very first article under right to freedom. Article 19 essentially protect certain rights of citizens. Now, what does that mean? That means Article 19 is available only to the citizen and it is not available to the foreign national. Now, this is one point that you need to take care of. You need to remember because it is generally asked in your preliminary examination. Now, there are under Article 19, Clause 1. So, let us discuss the structure of Article 19 first. So, it is Article 19. There are six clauses under Article 19 where one provides you the six fundamental right. ठीक है? Six type of freedom where Article subclause 1 is dealing with six rights. Subclause clause 2 to clause 6, they are dealing with restrictions on the six rights which are present under subclause 1. So, under clause 1. So, we'll be discussing clauses and simultaneously their restrictions. So, Article 19, clause 1, subclause A, provide freedom of speech and expression. This is the very first freedom which is given under right to freedom. Article 19, clause 1, subclause A. Okay. So, freedom of speech and expression. Now, what does the term speech and freedom of speech and expression implies? See, that means you are able to express your thoughts, you are able to speak whatever you want to, okay, freely in India, openly, and through any means, any medium. You can use any mode of communication. It can be through written, it can be oral, it can be through pictures, and it can be through paintings. You can express yourself the way you want to. Okay. And this is not a single right, it is a composite right. That means there are many associated rights along with the freedom of speech and expression. It is not just a term, it is a composition of many rights coming together. Let us discuss. So, when you are saying that you can express yourself in any medium, that means you can also opt not to say anything. That means you have a right to say silence. This was highlighted by Supreme Court in one of its judgment. Okay, so this is one interpretation of freedom of speech and expression. The another interpretation goes to freedom of press. It provides you the freedom of press. Why? Because when you say that you have a right to express yourself, so press is also a medium to express. You get to write your opinion in newspaper. You get to speak your mind when you're coming to a news channels. You are, you know. So this is also something which is giving you a right, a platform to express yourself. Thus, freedom of press also flows through freedom of speech and expression. Okay. Now, it was in Union of India versus ADR, that is Association of Democratic Reforms. Association of Democratic Reform case of 2002, where Supreme Court highlighted that if a citizen have a right, freedom of speech and expression, right? So they also have a right to express themselves during voting, which is a democratic process of the country, right? And at the same time, how will you be able to express yourself in a rightful manner? For that, you need to have the ability to make informed choices. Thus, freedom of informed choices also flowing through speech and expression. Now, what are the consequences of this? The consequences is that the citizens should be aware of the background, criminal cases, if any, or the property which an individual have to declare when he or she is contesting for the elections. That means the citizens will be able to make informed choices, so they must be aware of the background, the criminal cases, if any, or the civil cases, if any, are pending against that particular individual who is contesting the elections. So right to informed choices was also coming from speech and expression. And coming from this, it was in 2013 that People's Union of Civil Liberty case versus Union of India, that Supreme Court said, if you can choose, here it is saying that you can choose. Here it is also saying if you can choose, you also have a right to reject. This is your right to reject. So, nota, that means none of the above option. You have rejected all the candidates who are contesting elections and you choose none of the above option. This is also coming from speech and expression. This is also your right to expression. Okay. Another thing is right to dissent. What does dissent mean? Dissent means to disagree with the government policies. Disagree with the government policies. So, it is also a way of expression that you can criticize government policy. You can say, okay, this particular policy or step of the government is not right. This is also a part of your speech and expression. Further, it also said that dissent does not amount to sedition. Okay, so these are the rights which are available under speech and expression. Another very important right is your right to information. How will you express yourself? How will you say? How will you, go to a level of dissent if you're not available of the policies which are there, what is going on in the government? You have to get that information, and that is why right to information is also a fundamental right under freedom of speech and expression. Okay. Now, now these are the freedom which are given. However, there are certain restrictions which are being imposed on the usage of freedom of speech and expression on the citizens. What are these restrictions? They are not absolute. When we were discussing the basic features of fundamental right, there also we discussed that fundamental rights are not absolute rights, and we are witnessing them in the previous rights also that we had discussed. So fundamental right to freedom is also coming along with some restrictions on it. So on speech and expression, these are the area of restrictions. If your speech and expression is hampering any of these area, then that has to be restricted, and that is why these restrictions are reasonable. Restriction cannot be unreasonable. Unreasonable restriction नहीं हो सकती. It has to be reasonable. So if your speech and expression is impacting sovereignty, integrity, security of the state, it is impacting friendly relation with the foreign state, public order, decency, morality, contempt of court. If any of these is happening, then it is these are the ground for the restriction. Okay. Say for example, we have seen many a times, whenever there's a sort of a riot like situation, government imposed a sort of ban on the internet, you know to prevent the dissemination of the information. Okay, to control the situation, that means to control the public order, to have public order. If your freedom of speech and expression, we see that in India, if you see, there are statements which are anti-national statements. We have seen that Nara like Bharat Tere Tukde Honge. That is an anti-national. You cannot support such kind of argument. These kind of speech and expression will lead to incitement of the violence. They will lead to anti-national elements, a chaos in the country, and that is why such sort of speeches has to be banned. They are restricted under the they are restricted freedom of speech and expression. Okay. So if another thing is defamation. Now what does the term defamation means? Defamation means if you are defaming, if you are disreputing an individual, okay, or an organization, that is referred to as defamation. Defamation is a reasonable restriction on freedom of speech and expression. Okay, that while using your freedom, you cannot defame others. Now, this is an area where we have seen that a lot of disagreements are happening, and we have seen that many people are saying that you should be doing away with the defamation charges because it somehow restrict the freedom of speech, it restrict freedom. Further, it can be misused. And third, it also lead to judicial harassment. So if we see the IPC, there are two sections of IPC which are dealing with the defamation. They are 499 and 500. And there are two implications of defamation. What is civil? One is criminal. So article section 499 deals with it establishes defamation as a criminal crime, and article section 500 prescribe a imprisonment of not more than 2 years. Okay. So if you have been reading newspapers, you must have come across the controversy regarding the Rahul Gandhi remark on the Modi surname, right? So the issue was taken to the High Court. Gujarat High Court said that it is a defamatory act, and that is why they give him the imprisonment of 2 years, which is the maximum imprisonment under under section 500 of IPC. Now, due to this, he was disqualified from being an MP. Okay. When this issue was taken to the Supreme Court said that there was no rationale behind sending him for an imprisonment of 2 years, and the Supreme Court stayed the decision. That is why it is being alleged that this can be misused. It has been misused, and it can be further misused to for the political motives. Okay. However, it wasn't Subramaniam Swamy versus Union of India 2016 case. That is Subramaniam Swamy versus Union of India 2016 case that Supreme Court said that we cannot do away with the criminal proceedings of the defamation section 499 and 500. Why? Because the reputation that one has earned is very hard earned, and nobody can come and say a remark which it can be taken away in fraction of seconds. So that is why it cannot be taken away. Say for example, if you see in today's time, with the coming age of technology, we have seen that deep fakes are there, and then there is this entire pornography that can be faked. Okay, which is used as a tool to defame others. Although the defamation through internet is being dealt by the IT Act, not by this particular act, but imagine if these are the things which are happening despite there are certain regulation, because the area is such that it cannot be regulated. Similarly, imagine if there are no restrictions at all. It can, cause a lot of harm to the people, to the community, to the organization. That is why keeping it free is very difficult. Okay, so that's what Supreme Court said, that a reputation is very hardened and you cannot take away. Second, it also said that if we are only keeping civil charges for that and we are taking away the criminal charges, what is happening in the process, that it might happen that the defamer is not able to pay the compensation which is given, for the which has to be given for defaming others, because it can be huge. So how are you going to make sure that they are able to pay? Third, it also said if we take away the criminal, that it will be acting as a no deterrence or less deterrence. It will not be able to deter the defamation speech. So that is why the Supreme Court held that we cannot take away, we cannot be doing away with the defamation charges. Another is incitement to an offense. See, if any speech of yours is leading to, causing violence in the country, now that has to be a reasonable restriction on your freedom of speech and expression. You cannot make such speeches, you cannot make hate speeches. And that is where Article 124A sedition comes into picture. Okay. Now, what does it means is, what does the term sedition imply? Sedition means going against the interest of the country, hate speeches which are leading to the leading harm to the country. It in Hindi means Rajdroh. Okay, so the people who are in favor of removal of the sedition charges are saying that it is a colonial legacy. Why do we need it in democratic setup? People can say that they can voice their opinions if they don't like anything about the government. What is harm we should be doing away with this particular article, section 124A. However, Supreme Court in Kedarnath versus Union of India, Kedarnath versus Union of India in 2016 said that the section 124A, which is dealing with sedition, is important for the security of the state. It is important for the security of the state. Okay. Now, along with this, it outlined a principle, on the basis of which we can say that this particular act is an act of sedition, and this particular act is not an act of sedition. It says that any sort of dissent or disagreement, it can be offensive as well. In how harsh a language can be, there is no harm in using that. That doesn't amount to be sedition until and unless that particular speech or expression is leading to incitement of violence. If your speech and expression is not leading to an act of violence, till the time it is not leading to act of violence, it is fine. But when it is leading to an act of violence, then that is something which is referred to as sedition, and that should be punished. And that should be punished under article section 124A. That now these are the reasonable restriction, and these are the important controversy that are revolving around uh, freedom of speech and expression, and these two are the potential question for your mains examination as well. So be prepared for these two questions. Now let us move to the second freedom. So Article 19, Clause 1, Subclause B, it also allowed to assemble peacefully and without arms. That means it provide you to the right to assemble. You can assemble, but there are two conditions. Your assembly has to be peaceful and it has to be without arms. You cannot assemble with arms because that will be against the public order and sovereignty and integrity of the country, which is a reasonable restriction mentioned under Article 19, Clause 3. Okay, so these are the two restrictions which are mentioned: public order, sovereignty, and integrity of the country. You cannot just come together with arms and lead into a mass movement and say, okay, this is a freedom of speech and expression, and sorry, this is a freedom to assemble, so we are doing it. No, because that will be a threat to the sovereignty of the country. Okay, further to the public order as well. That is why, if you see, if there is any sort of riots like situation, article section 144 of CRPC, which is leading to the curfew. Okay, government imposes the section so that they can bring the situation in control, and they can stop the assembly of more than four people together in outside area to prevent and maintain public order. Okay. Now come to Article 19, Clause 1, Subclause C. It says it gives you right to form association or union or cooperative societies. The term cooperative society was added by 97th Constitutional Amendment Act. It says that you can form any sort of association of any nature. It can be political, it can be social, it can be cultural. Any sort of organization or union you can form. You have the liberty to do that. However, it is subjected to the restrictions: sovereignty, integrity, public order, morality. Your association cannot go against these. So that is why the organization which are the insurgents organization which are fueling violence in the country, they are banned. Some are even under UPA. ठीक है? So that is why you can form association union which are subject to sovereignty, integrity, public order, morality. Okay. One more thing, when it says that you can form association, it doesn't guarantee you not the fundamental right to be admitted. It's not that if you want to get admitted you must get the admission. No, you can form, but every organization has certain norms, and there has to they if they have certain criteria for their organization, so it is their choice to let you admit or not. It is not your right to get admitted. That's not your fundamental right. You can form, but to get admit or not is not your fundamental right. Say for example, there is any sort of political party. Okay, today there is a political party which is coming up, and you want to join that political party. Now what is happening? You say ki okay, it is my fundamental right to be a part of an to form an organization, association or a union. Why are you not letting me in? No, because your to get admitted is not your right. Okay, that's not your fundamental right. So this is one thing. And when we are talking about union, it also guarantees the fundamental right to form trade union. However, there is a issue with respect to the trade union. That is, this is very commonly asked, that right to form trade union doesn't guarantee you the right to strike. Okay, this is your statutory right. And also there are two type of rights. One are bandhs, other are hartals. Okay, now bandh are not legal, they are illegal, because they in they lead to total paralysis of the working, and they also coercion का element रहता है इनके अंदर. They also have an element of coercion. However, hartal do not lead to total paralysis and do not have an element of coercion, whereas bandh have. So in CPM versus Bharat Kumar 1998, the Supreme Court held bandhs are illegal. Now let us move to the next set of the rights. So it is Article 19 Clause 1 Subclause D, which allows you to move freely throughout within the country, and Article 19 Clause 1 Subclause C gives you the right to reside and settle in any part of the country. Now what does this mean? This is your right to movement. That means you can move wherever you want to, whenever you want to, however you want to. कहीं पे कैसे भी कभी भी आप जा सकते हो within the territory of the country. That is the right which is given to you by Article 19 Clause 1 Subclause D. Okay. However, there is another facet of right to movement, which is move outside the country. Move outside country and return to the country. Now, this is the aspect which is not given to you by Article 19. Article 19 allows only within and throughout the country. moving outside the country is given to you by Article 21, which we will discuss later after this particular article. Okay. Now, together, 19 and 21 guarantees you right to movement. Coming to Article 19, Clause 1, Subclause E, it allows you to reside and settle in any part of the country. Okay. Now, what does the term reside and settle mean? Reside simply means temporary settlement. Settle is permanent. Now, say for example, today you decide to go out to Goa or maybe Manali or Shimla for a holiday, for a vacation. You will stay somewhere, right? Now, that is residence. You are residing at a particular place. That means if you're moving out, you have a right to reside also. At the same time, you also have a permanent home, you have permanent address where you stay. That is your settlement in the country. So, both these articles are um, complementing each other, and however it is Article 19 clause 5 which is restricting these two for interest of general public and protection of interest of scheduled tribes. Okay, interest of general public, how you can say interest of general public? See, you must have seen like there are at times when there was corona was there, COVID was there, your right to movement was restricted. You were not allowed to move out. That was in favor of general interest of public and protection of interest of scheduled tribe. Here is where your concept of inner line permit, because they have different culture, they have different living style. So that is why, to protect their interest, they are vulnerable people, to protect the vulnerability, to give them that safe environment to be in, you have a provision of inner line permit. This is where your movement is restricted. Other than that, you are free to move, reside and settle as per these two rights. Now let us have one more thing. Both of them are serving the objective of maintaining territorial integrity and promoting fraternity among people. Okay. Now let us move to the last set of right which is given by Article 19. It gives you right to avocation. That means to practice any profession, any occupation, trade or business. That means you can decide, you can choose the career, the way of earning that you feel like doing it. Okay, you can choose any profession, any career, any sort of occupation, any business. You can do whatever you want to. However, it has been restricted on two grounds under Article 19, Clause 6. One is that state can set up some necessary qualification for a particular job. Okay, now, say for example, today you decide to be a doctor and you said, okay, fine, I want to start a clinic. You can do it, it's you're right. But do you have the necessary qualification? Have you done your MBBS? Have you done your MD? If you haven't, you cannot. But if you say, oh no, I have a right to have a profession um, of my choice, so why can't I? Because the state can set up some necessary qualification. It is a very responsible job. You need to be qualified enough to treat a patient. Similarly, if you see, you all are giving civil services exam today, and tomorrow say anybody says ki it's my right to have any profession, so why can't I be civil servant? Surely you can, but you have to be qualified for that. You have to go through the process of the civil services examination, and you have to qualify all the three stages. You have to meet the health parameters or any other physical parameters or mental parameters which are required to be part of a particular profession. That is what the first provision means. Second, it says that state can take over businesses in public interest, prohibit business in liquor, money, lending, betting or gambling. Public interest के अंदर, in the favor of public, state can take over any business, or it can also prohibit businesses in liquor, money lending, betting or gambling. Okay, so this is what state can do. And there are two associated cases. Maharashtra government banned cow slaughter. The government banned the cow slaughter. However, when this particular action was challenged in Qureshi versus State of Maharashtra case in in Bombay High Court, the High Court said that the complete ban on cow slaughter is not constitutional. It is not justice. It is not. It is void. It is not right because it is under going against Article 19, Clause 1, Subclause G to practice any profession that one can do. Okay. However, it said that government can restrict or regulate this because it is under Article 48, which is your DPSP. It is the government duty to protect milch animals, including cow. Okay. It also mentioned that the mere possession of beef does not amount to a criminal offense. It is not a criminal offense. However, it took away the complete ban, but it is still a question like how do you regulate the ban as well as the, how do you protect? They are going against each other, but there need to be a balance which need to figure out how do you do that. The case is still sub judice under the Supreme Court, but we are yet to see the result of it. Second, Maharashtra again banned dance in bars. Now, Supreme Court also said now this ban is also not constitutional because it is against going the spirit of Article 19, Clause 1, Subclause G. However, it said that you can check, you can regulate that there are no immoral activities going on in the bars around this area. However, if you are banning them completely, then it is going against the right of the bar owner as well as the dancers who are dancing in that particular bar, because it is their right to choose the profession of their own choice. Okay, so that was it about Article 19. If you have any questions, any doubt, you may please ask in the comment section below. And in the next video, we'll be discussing Article 20, 21, and 22. Till then, take care, have a good day, revise this, and if you have any question, please ask. We'll be discussing the previous year questions after we complete the article of right to freedom. Thank you. Have a nice day.